ओके सो इस वीडियो में हम बात करने वाले हैं कंपनीज एक्ट 2013 के सेक्शन नंबर 20 एंड सेक्शन नंबर 22 के बारे में। सेक्शन नंबर 20 सर्विस, सेक्शन नंबर 20 और सेक्शन नंबर 22 के क्वेश्चन आंसर्स के बारे में। कुछ टोटल मिला के 3 या 4 क्वेश्चन ही है, ठीक है। 10 मिनट में तो खत्म हो जाएगा दोनों सेक्शंस। सो लेट्स स्टार्ट विथ सेक्शन नंबर 20 सर्विस ऑफ डॉक्यूमेंट्स। Question is, explain the provisions of the Companies Act 2013 relating to the service of documents on a company and the members of the company. Under Section 20 of the Companies Act 2013, a document may be served on a company or an officer, thereby sending it to the company or the officer at the registered office of the company by registered post, speed post, or by courier services, or by leaving it at the registered office, or by means of electronic or other mode as may be prescribed. However, in case where the securities are held with a depository, the records of the beneficial ownership may be served by such depository to the company by means of electronic or other mode. Under Section 20, subsection 2, save as the provided in the Act or in the rule thereunder, for filing the documents with the registrar, in electronic mode, a document may be served on registrar or any member by sending it to him by post or by registered post or by speed post or by courier or by delivering it at his office or address or by such electronic or other mode as may be prescribed. However, the member may request for delivery for any document through particular mode. For such, he shall pay such fees as may be determined by the company and its annual general meeting. Next question. Vijay, a member of Mayur Electricals Limited, gave in writing to the company that the notice for any general meeting be sent to him only by registered post at its residential address at Kanpur, for which he deposited sufficient money. The company sent notice to him by ordinary mail and certificate of posting. Vijay did not receive this notice and could not attend the meeting and contended that the notice was improper. जो कि थी भी. Decide whether the contention of Vijay is valid. Yes. Will your answer be different? Will your answer be same if Vijay remains in London for 2 months during the notice of the 23 meeting and the meeting held? Okay, so answer is, according to section 220 subsection 2 of the Companies Act 2013, the document may be served on a registrar on registrar or any member by sending it to him by post or by registered post or by speed post or by courier or by delivering it at his office or address or by such electronic or other mode as may be prescribed, provided that member may request for delivering any document through a particular mode, for which he shall pay such fees as may be determined by the company in its annual general meeting. Thus, if a member wants to notice to be served on to him only by registered post at his residential address at the Kanpur, for which he has deposited sufficient money, the notice must be served accordingly, otherwise service will not be deemed to be effected. Accordingly, the questions asked may be answered as under the contention of Vijay shall be tenable and for the reasons that the notice was not properly served. In the given circumstances, the company is bound to serve a valid notice to Vijay by registered post at his residential address at Kanpur and not outside India. मतलब भाई देखो, कंपनी ने गुनाह तो किया है, ठीक है, कि रजिस्टर्ड पोस्ट की जगह तुमने नॉर्मल पोस्ट या फिर किसी और मोड से तुमने मतलब नोटिस भेज दी, लेकिन जहाँ पे भेजनी थी वहाँ तो भेजी है। और अगर रजिस्टर्ड पोस्ट से भेजते तो भी कानपुर में, जो कि उन्होंने एड्रेस दिया है, उन्होंने बोला है वो कानपुर में ही भेजेंगे। हमें घंटा फर्क नहीं पड़ता कि तुम कानपुर में हो या फिर 2 महीने के लिए लंदन चले गए, लेकिन तुमने अगर हमें बोला है कि भाई रजिस्टर्ड पोस्ट से मेरे इस एड्रेस पे देना, तो मैं रजिस्टर्ड पोस्ट से उसी एड्रेस पे दूंगा। अभी मेरे को क्या पड़ी है कि तुम 2 महीने के लिए बाहर हो, यहाँ पे गए हो, वहाँ पे जाना जरूरी है, ठीक है। नेक्स्ट क्वेश्चन, बट द सेक्शन नंबर 22 एग्जीक्यूशन ऑफ बिल्स ऑफ एक्सचेंज। एक ही क्वेश्चन है, ठीक है, एक ही क्वेश्चन है। मेरे को अच्छा लग रहा है, पता नहीं क्यों, लेकिन इसलिए ही पढ़ रहा हूँ, ठीक है। सेक्शन नंबर 22 एग्जीक्यूशन ऑफ बिल्स ऑफ एक्सचेंज। Question is, Parag Construction Limited is a leading infrastructure company. One of the directors of the company, Mr. Parag, has been signing all the construction contracts on behalf of company for many years. All the parties who ever deal with the company, Mr. Parag very well. Company has got a very important construction contracts from the renowned software company. Parag Construction will do construction for this site in partnership with local contractor Firoz Bhai. Mr. Parag signed partnership deed with Firoz Bhai on behalf of the company because he has implied authority. Implied authority पे यहाँ पे जोर करना क्वेश्चन में दिया है. Implied authority later in a dispute company denied to accept the liability as a partner. Can the company deny its liability as a partner? As per Section 22 of the Companies Act 2013, the company may authorize any person as its attorney to execute deeds on its behalf in any place either in or outside India, but common seal should be affixed on his authority letter, or the authority letter should be signed by two directors of the company, or it should be signed by one director and secretary. This authority may be either general may be either general for any deed, or it may be for any specific deed. A deed signed by such attorney on behalf of the company and undertake his seal shall bind the company as if it were made under its common seal. In the present case, company has neither given any written authority nor affixed any common seal of the authority letter. It means Mr. Parag is not legally entitled to execute deeds on behalf of company. Therefore, deed executed by him are not binding on the company. Therefore, company can deny its liability as a partner. मतलब ये क्वेश्चन इस टाइप के क्वेश्चन आ सकते हैं, पता नहीं क्यों पूछ नहीं रहे, क्या पता नहीं बाकी लोगों ने इसको इम्पोर्टेंट क्यों नहीं बताया है, लेकिन मेरे लिए आई थिंक ऐसा क्वेश्चन पूछना चाहिए. बढ़िया क्वेश्चन है यार, कि भाई देखो तुम्हें गुमराह तो बढ़िया तरीके से कर रहे हैं कि भाई सारे के सारे डीड तो यही करता है ना, यही बंदा सबको पता है कि यही साइन करेगा और करता भी है सब है. लेकिन जब बड़ा कोई कॉन्ट्रैक्ट आया, जब तुमने पार्टनरशिप डीड बनाई, उस पर साइन करी, तब तुम बोलते हो कि देखो ये जो हमें ना कोई इम्प्लाइड अथॉरिटी तो पहले तो तुम्हें मिलेगी नहीं, ठीक है, हमसे साइन करवाओ पावर ऑफ अटर्नी पे, ठीक है. उसमें या तो हमारी कॉमन सील होगी, या तो दो डायरेक्टर साइन करेंगे, या तो एक डायरेक्टर और एक कंपनी सेक्रेटरी साइन करेगा और तुम्हें ऑथोराइज करेगा, क्योंकि तुम सारी डीड्स में एंटर हो सकते हो, या फिर तुम कोई पर्टिकुलर स्पेसिफिक डीड में एंटर हो सकते हो. यहाँ पे ऐसा कुछ हुआ क्या? नहीं हुआ, ठीक है. तो भाई हम लायबल नहीं है, सो कंपनी कैन डिनाई इट्स लायबिलिटी. बस यही क्वेश्चन का ये क्रक्स है, ठीक है, सत्य है. बाय बाय.